Welcome to the annual J. Byron McCormick Lecture at the James E. Rogers College of Law of the University of Arizona. The McCormick Society honors J. Byron McCormick and supports this annual lecture on law and public policy. McCormick joined the College of Law faculty in 1925 and became its second dean in 1938. He left the deanship in 1947 to become the 13th president of the University of Arizona. Among other achievements, Dean McCormick strengthened faculty governance and established the first staff-faculty retirement system. After he stepped down from the presidency in 1951, Dean McCormick returned to law teaching and served as advisor to the Arizona Board of Regents until his death in 1970. This society was formed decades ago by his former students, colleagues, and friends as a tribute to him and as a great gift to our intellectual community. The McCormick Lecture is one of the oldest continuing distinguished lecture series here at the University of Arizona. Our college is the first law school in Arizona, and the University of Arizona was the first university in the state. University of Arizona also is the land-grant university in Arizona. And as a land-grant institution, outreach and service are core to all of our work. We're very grateful to the members of the Society whose generous contributions make this much-loved lecture series possible. Their commitment to advancing the world of ideas, their fidelity to the University and the College of Law and the wider communities we all serve, both here and globally, are part of what makes the University of Arizona and the Arizona law community so powerful. We welcome new members to carry the vision of the founders forward and to keep this voice of law and public affairs vibrant. Please join us. If you go to the College of Law website, www.law.arizona.edu, you can get information about past lectures, future events, and how to join. We sure hope you'll enjoy tonight's speaker, who now will be introduced by the Dean of the University of Arizona, James E. Rogers College of Law. Again, welcome.
Hello. Today, the McCormick Society and the William H. Rehnquist Center on the Constitutional Structures of Government bring us a timely and compelling program from lawyer and law professor David Cole, the National Legal Director for the American Civil Liberties Union. Every era has its own heroes, committed to civil rights and liberties. Clarence Darrow, Thurgood Marshall, and Ruth Bader Ginsburg come readily to mind. David Cole is in the midst of a career that calls his name to that list. Since David and I are the same age, I should note that he is obviously a youthful member of this special group. But the case has at least been made. The task of defending our civil liberties and promoting our civil rights has no natural end. It is instead a continuing process. The process of defending our civil liberties calls back to other times of great strife and controversy. Now, as in the past, we are at a watershed moment in our history as a nation. From the Palmer raids to the Portland arrests, from internment camps to detention facilities, from the Scopes trial to determining the weight of science knowledge in a pandemic world, each generation finds and defines its own leaders. We are fortunate that David Cole is one of ours. In his role as National Legal Director for the ACLU, David Cole directs a broad and complex operation that at any given time can include 1,400 state and federal cases. David has litigated many constitutional cases in the Supreme Court, including Texas versus Johnson and United States versus Eichmann, which extended First Amendment protection to flag burning. Masterpiece Cake Shop versus Colorado Civil Rights Commission, in which the ACLU represented a gay couple refused service by a bakery because they sought a cake to celebrate their wedding. And Harris Funeral Homes versus Steffens, which asked whether Title VII bans discrimination on the basis of transgender status. Professor Cole is on leave from Georgetown University, where, since 1990, he has taught constitutional law and criminal justice. He has a broad platform in the public square as a regular media guest and a frequent contributor to The Nation, the New York Review of Books, and the Washington Post, among others. A prolific author, David has authored 10 books, several of which have won awards, including an American Book Award, and all of which have earned critical acclaim. The late Nat Hentoff called him a one-man committee of correspondence in the tradition of Patriot Sam Adams. As you might expect, he has been recognized with honorary degrees and numerous awards for his work. Our program today will be conducted as a conversation with Professor Eunice Lee, who we welcomed just a few weeks ago as our newest member of the Arizona Law faculty. Before joining us, Professor Lee served as the co-director of the Center for Gender and Refugee Studies at Hastings Law School, where she, like David, led impact litigation efforts that have been highly intersectional and have informed today's extraordinary legal environment. Please join me in thanking the members of the McCormick Society, as well as the Rehnquist Center, who make today's program possible, and join me in welcoming Professor Lee and Professor Cole.
Great. Thank you so much to Dean Miller for that introduction, and to our guests, our distinguished speaker, and the McCormick Society and Rehnquist Center for today's event. Before we get started, a couple logistical matters. First, the chat function in this webinar has been disabled, so if you'd like to pose a question to Professor Cole, you can submit it by clicking on the Q&A icon at the bottom of your screen. And we'll take audience questions as time permits toward the end of this program. And now to today's main event. Professor Cole, thank you again for being here with us today. I have to express my excitement not only on behalf of the University of Arizona, but also based on my own personal connection to the work that you do. My first job out of law school after clerking was as an Equal Justice Works Fellow at the ACLU Immigrants' Rights Project in New York, where our litigation docket was, of course, under the direction of your predecessor. It was my dream job, which I was lucky enough to get as a very beginning attorney, and I could not imagine a better place to have learned from the outset not only how to be a litigator, but also how to use law to advance justice in our society. So my first question for you is, Professor Cole, can you tell us about your current role at the ACLU, and also a bit about why you decided to temporarily leave the academy for this job?
Sure. Well, let me start by thanking the university and the McCormick Center and the Rehnquist Center for having me. I very much wish I could be there in person. I know we all do, but we will do what we can via Zoom. And thank you also to Dean Miller for such a effusive introduction. You know, it's the kind of introduction that would prompt Justice Brennan, when he was alive, to say, thank you. I wish my parents could have heard it. My father would have been so proud, and my mother would have believed it. So thank you, Dean Miller, for that. So, I was a law professor for 25 years. I litigated constitutional cases during that time as a volunteer attorney with the ACLU and with the Center for Constitutional Rights and the like. But in the summer of 2016, my predecessor, Steve Shapiro, who was the National Legal Director of the ACLU for 25 years himself, stepped down, and Anthony Romero, the leader of the ACLU, came to Washington to encourage me to apply for the job. And he basically said, David, how can you not apply for this job? And you have to think back to the summer of 2016, a very different time, obviously, than the summer of 2020. And so what was Anthony's pitch? His pitch was, you've been litigating constitutional cases, teaching constitutional law, writing about constitutional law for your entire career, 30-some years, under a conservative majority Supreme Court. Just think what it would be like to head up the ACLU, and particularly its Supreme Court practice, because that's a big part of what I do as the National Legal Director, under a liberal majority Supreme Court. And, again, think back to the summer of 2016. What did we know in the summer of 2016? Everybody knew Hillary Clinton would be the next president. Donald Trump knew Hillary Clinton would be the next president. And therefore, she would appoint Justice Scalia's successor. And for the first time in 40 years, we'd have a liberal majority Supreme Court. So I said, sure, how can I turn that down? And I applied. I was lucky enough to get the job. And then I signed the contract in the summer of 2016, without any what if clause, because, who thought there would be any what if? And obviously the job changed dramatically on November 8th of 2016. I actually formally began in January 2017 because I was finishing up teaching in the fall. But, I'd had my staff there working on memos about how we could advance civil liberties and civil rights concepts under a liberal majority Supreme Court, something that we hadn't had for 40 years. Those memos are of only historical interest at this point. Obviously, the job changed dramatically on November 3rd, and I ended up starting about 11 days before President Trump took the oath of office. So it's been a wild ride, as you might imagine.
Well, so the pitch was a little bit different than the actuality, it seems. Unfortunately, for my next question, you did publish a book, and you finished writing that book before you began your job in January 2017. Otherwise, it seems we may never have seen that book. So fortuitous timing there. So in that book, Engines of Liberty, How Citizen Movements Succeed, you explored 3 citizen movements in the areas of marriage equality, the right to bear arms, and human rights in the war on terror. The ACLU, of course, featured prominently in the first and third of these movements. Can you share with us the major lessons of this book?
Yeah, I wrote Engines of Liberty after, both teaching constitutional law for 30 some years and practicing it. And my sense was that when we teach constitutional law and when newspapers write about constitutional law, they focus on what lawyers argue in court, what the briefs say for one side, what the briefs say for the other side, and how the judges reason to their decisions. And that is part of constitutional law. But I think if you try to explain how constitutional law changes, how it develops over time, that is a patently inadequate explanation, right? So I decided to look at 3 what I think are successful constitutional reform efforts in our lifetime, and see sort of how do you explain how this happened. So how did marriage equality go from something that was unthinkable in the 1980s to something that was inevitable when the Supreme Court decided the Obergefell case in 2015? How did the right to bear arms, which was rejected by Chief Justice Warren Burger, a Republican conservative former Chief Justice, in 1989, he said, the notion that the Second Amendment protects an individual right to bear arms is one of the greatest frauds perpetrated on the American public in my lifetime. That was 1989. For 100 years, the courts had said the Second Amendment does not protect an individual right to bear arms. How did it happen that by 2008, the court ruled in the District of Columbia versus Heller that indeed the Second Amendment protects the right to bear arms? And then the war on terror with George W. Bush after 9/11, where the president locked people up without charges. It's authorized warrantless wiretapping of American citizens, authorized disappearance of Al-Qaeda suspects into secret prisons, and torture. How did it happen that by the time President Bush left office, he had released over 500 of the people from Guantanamo. The warrantless wiretapping program was shut down. The secret detention centers were closed, and torture was no longer authorized. How did those things happen? And what I argue is they happen through the work of a lot of different people in a lot of different organizations working together, using the tools of democracy and the courts through civil society to advance a particular vision. And so take the marriage equality. 1972, an ACLU lawyer represented a gay couple in Minnesota and argued that they had a right to marry on the same terms as a heterosexual couple. And the Supreme Court of Minnesota was so offended by the ACLU lawyer's argument that the court did not ask a single question to the ACLU lawyer. One of the justices turned his back on the advocate for the entirety of the argument because he was so offended. Shortly after the argument, they issued a short opinion rejecting the claim, citing the book of Exodus, not usually or the book of Genesis, not usually a constitutional authority. And when the couple appealed to the Supreme Court said, there's not even a serious federal question here, and rejected review. And what were their arguments? Due process and equal protection. Fast forward to 2015, what were the arguments? Due process and equal protection. The same arguments. So the arguments didn't change. The court changed, but the court, if anything, the court in 2015 was more conservative than the court in 1972. What changed was not the court, not the arguments, but the world changed. The context in which the court was addressing those arguments changed, so that arguments that had been rejected as dismissed as completely frivolous carried the day. And the way gay rights groups got there, including the ACLU, but Lambda, Legal Defense Fund, and many Freedom to Marry and many other groups, was through incremental change, very careful, asking for small changes, focusing mostly on states, staying out of federal court, developing recognition of the right in small ways, family law, anti-discrimination provisions in particular cities and states and the like. Then they went to state court in Vermont, where I am now, one of the most progressive states in the country, and they got the first win recognizing civil unions. Then they went to Massachusetts and got the first win recognizing marriage equality. And these were based on state constitutional arguments, not federal constitutional arguments. Why? Because they wanted to stay away from the Supreme Court until they were ready. And ultimately, they got enough decisions, both through state legislatures, state courts, the DC City Council, and the like, to make it possible to go before the Supreme Court and win. So it's that kind of work by civil society operating not just in courts, but in legislatures, in town councils, in corporate boardrooms, around the dinner table. It involved a lot of the progress was made by gay people coming out, identifying as gay, so that many people began to realize that, hey, I know somebody who is gay, and it's much harder to demonize when you know somebody than when you don't. And the NRA did pretty much the same thing. They worked state by state. They didn't start in Vermont. They started in Florida, but state by state, and got a right to bear arms recognized in virtually every state in the union before they got to the United States Supreme Court. So at that point, the court simply had to, sort of put the period at the end of the sentence. So it's a long-winded answer, and I promise it'll be the longest answer I give you, but I was trying to summarize a whole book. But the idea is engines of liberty are us, are citizens who come together in associations of people who believe in a particular set of values. And, it works for conservative values like the right to bear arms, and it works for liberal values like marriage equality. But that is actually how constitutional law changes.
So related to that lesson, you mentioned a number of different organizations, but you, of course, are the National Legal Director of the ACLU. So specifically speaking about the ACLU, how does the ACLU figure into citizens' movements and function as an engine of liberty, generally speaking? And how do you conceptualize the role that the ACLU plays in our constitutional order?
So the ACLU has been around for 100 years. This is our 100th anniversary. We were going to have a huge 100th anniversary gala party in March, which obviously was canceled because of COVID. And, it started out as a relatively small group of lawyers. It was for a pretty long time a relatively small group of lawyers. But what it did was it advocated for the rights within the Bill of Rights, and first and foremost for the First Amendment, for the right to speak up, the right to associate, the right to dissent, the right to petition government for redress of grievances, the right of the free press. And in some sense, that is the right that protects civil society. It is the First Amendment that protects all of us, gives all of us the right to join together with others in defense of things we believe in. And that's how democracy works. And democracy only works as long as that freedom is available for everybody, for the left-wing extremist to the right-wing extremist to the centrist in the middle. It's got to be for everybody. And so the ACLU played a major role in defending the right to protest and expanding the right to free speech and fighting back against McCarthyism and defending civil rights protesters and the like. And today we are a very large organization. We have about 500 employees in our national office, and we have about another 1,800 employees scattered throughout the states because we have affiliates in every state. We had, before President Trump was elected, 400,000 members. Those are people who have, signed up, gotten a card, are on our mailing lists, joined the ACLU. After Trump was elected, that our membership went from 400,000 to 1.8 million members. And I think that, think of that, 400,000 to 1.8 million in about 6 months. And I think what that reflects is an understanding among Americans that civil society is critically important, that when you're concerned about something, you don't just sit back and say, oh me, oh my, and there's nothing I can do about it, but you actually, you get up, you stand up, you join with those organizations that are advocating for those values, whether it's the right to bear arms or whether it's responsible policies to respond to climate change or immigrants' rights or LGBTQ rights or what have you. That's the way our democracy works. And what we saw at the ACLU in the wake of President Trump's election was that people recognized that and people came forward. And we weren't the only ones. Planned Parenthood, I think, has never had more support than it has today because it's under attack by the Trump administration. The New York Times and the Washington Post have never had subscription rates as high as they have today because people understand that the free press and shedding light on the what government is doing is an important part of checking abuse. And I see that across the board. I see it from the Women's March, the largest march in American history, put together in about 4 months after the president was elected, to the March for Our Lives, right? We've had many terrible mass shootings in my lifetime. But it was a mass shooting in Parkland, Florida, in the Trump administration that led to a mass movement of students and driven by students to call for meaningful gun control. The Me Too movement, Sexual harassment, I think it's been part of our society, probably since Adam and Eve, but it was only in the Trump administration that a mass movement to respond to sexual harassment rose up. To me, one of the highlights of being, my early days at the ACLU was we filed a challenge to the Muslim ban. And we filed the first challenge to the Muslim ban. We filed that on a Friday night, and the Friday night that he put it in place. And that weekend, tens of thousands of Americans went out to airports across this country to protest the Muslim ban. And they were, they were exercising their First Amendment rights. I think you've seen that, and most recently with the Black Lives Matter protests, again, massive protests. And I think it's no coincidence that all of these occurred in the wake of President Trump's election. I think it woke something up in people about the threats that we face and about the way we respond to threats in this country, which is through concerted civil society action.
So, Professor Cole, I'd like to follow up a bit on what you mentioned as the threats under the Trump administration. The title of this conversation, of course, alludes to the defense of liberty in the Trump era. And you've spoken about how the election of President Trump catalyzed these very large movements for change. But can you talk a little bit about what, if anything, is different about this era that we're in now, the Trump era?
Yeah, in some sense, everything is different. Just to put a number on it, right? We recently, we've been keeping track of the legal actions we've filed against the Trump administration since he took office. And we, as soon as he was elected, we took out full-page ads in the Washington Post and the New York Times that said, essentially said, President Trump, or President-elect Trump, because this was November 2016, we'll see you in court. If you do the things that you promised on the campaign trail that we think violate constitutional law, civil rights, civil liberties, we'll see you in court. So since then we've been keeping track of, how we're doing on seeing the president in court. And we recently filed our 400th legal action against the Trump administration, 400. So by comparison, during President George W. Bush's first term, in the height of the war on terror, we filed 18 actions against the George W. Bush administration, 400 against the Trump administration. And I think that's a reflection of just the breadth and aggressiveness of the threats on basic civil liberties and civil rights that this administration has put in place. So, fortunately, because we had so many people come to join the ACLU, we have more resources to respond to those threats. And so we've built up our teams, particularly in areas that Trump has attacked, like immigrants' rights, reproductive freedom, voting rights. And we have, indeed seen him in court, from the Muslim ban, to the most recent shenanigans regarding the census, which we just won a decision against his promise to not turn over the census numbers of all the people, as the Constitution and statute requires, but to exclude the undocumented immigrants among us before he turns that over. So, we have sued him, every week, and often more than once every week. And that's just, never before. It is true that the ACLU has sued every president in its 100 years. We sued President Clinton. We sued President Obama. We sued both President Bushes, President Reagan. So that's not different. But the breadth and the aggressiveness of this president is different. And I would say that the sort of patent disregard for legality is different. And you see that in the one lost record. We don't have a specific one lost record. I'm happy to talk about some of our wins and some of our losses, but the NYU has been keeping a track of all of this administration's wins and losses across the board. not just civil rights, civil liberties, but environmental, it's what have you. And they've found that he has a 14% win record. He's lost 85% of the time. That's, and this is not a hostile judiciary to the president. This is a judiciary that includes a lot of Trump appointees. It includes lots of Bush appointees. It's a mainstream judiciary, but the mainstream judiciary has been ruling time and again against this president because he's not a mainstream president.
So I wish we had time to go over all 400 actions, but since we don't, can you summarize for us some of the major areas of work and major victories that the ACLU has had that you've alluded to just now?
Yeah, so, as I said, I think mostly the real focus has been in immigration, reproductive freedom, and voting rights. But, on immigrants' rights, we challenged the Muslim ban. We got the first Muslim ban struck down. Then he put out a second version. We challenged that. We got that struck down. Then he put out a third version. We got that struck down in the lower courts. But unfortunately, the Supreme Court, by a 5-4 vote, upheld that third version. But even that third version was significantly more narrow than the first two versions that we challenged. He's taken a host of measures to try to deter people from applying for asylum. The most extreme, the most cruel, the most inhumane was family separation. We challenged that. We succeeded. We have reunited over 2,000 families who were separated by President Trump. Why? Because he thought if he took children as young as 1 year old, if he took children away from their parents and locked them up in some undisclosed location, not even telling the parent where the child is, for an undisclosed amount of time, that would deter people from applying for asylum. An incredibly cruel policy. We challenged it as illegal. We prevailed in the district court, and we've, as I say, reunited thousands of families. He then said you can't apply for asylum if you haven't entered legally at a border checkpoint, even though the statute says anyone who faces a risk of persecution at home can seek asylum, whether they are here legally or illegally. The courts struck that policy down as well. His administration sought to deny undocumented teens in federal custody access to abortion when they learn that they're pregnant, in one instance by rape, and said they wanted to get an abortion, which is their constitutional right. His administration said, we're not going to let you out of the federal facility for the purpose of that abortion, because that would be facilitating the abortion. Even though they weren't being asked to pay for the abortion, they weren't being asked to pay for the car ride to the abortion facility. They were just asked to open the doors so that the person could go out, get the abortion, and come back. They would let the person go out to get their teeth cleaned and come back, but not to exercise their constitutional right to abortion. We won that case, got a nationwide injunction. When he sought to ask a citizenship question on the census in order to deter immigrants from responding to the census. The census is supposed to count all people, not just citizens. And it was specifically designed to aid Republicans and non-Hispanic whites and to reduce the count of Democrats and immigrants, which would then result in lower representation in places that have a lot of immigrants, and would also result in lower federal aid to all of those places. We challenged that, went to the Supreme Court. The Supreme Court 5-4 ruled that he can't ask people about citizenship on the census because it was a pretextual measure designed to aid Republicans and hurt Democrats. We challenged his locking up a U.S. citizen without access to counsel, without charges, without a trial. And we got a court to order that we be given access to that individual, and then we ultimately forced the administration to let him out because they didn't have any charges that they could pursue against him. It's really a remarkable. We've had a remarkable string of successes in in challenging the president's actions, from courts, from Republican appointed judges, from Democratic appointed judges, even from Trump appointed judges.
So I'd like to ask you specifically also, one area that we haven't spoken about yet that you alluded to earlier in the conversation is the movement for LGBTQ equality. So the work in this area, of course, by no means ended in 2015 with Obergefell's pronouncement of marriage equality. Last year, you argued Bostock v. Clayton County before the Supreme Court, and this year, the court issued a landmark decision in that case. Can you tell us a bit about that decision and also the legal and movement building strategies behind it?
Yeah, so yeah, that was a remarkable experience for me. Our client, Amy Stevens, was a transgender woman in her 50s who, in her 50s, realized that she was, in fact, a transgender and came out as transgender to her employer. She worked in a funeral home. She'd worked in a funeral home for decades. She was a very, highly prized employee of a funeral home in Michigan. But she took some time off after a lot of soul searching. She, wrote to her employer and said, look, this is going to become as a surprise to you. But I am, I've come out as Amy Stevens, and I am a woman, and I will be coming back to work as a woman. And he said, no, you won't. You won't be coming back to work. And so she brought an action. Actually, she went to the Equal Employment Opportunity Commission, the EEOC, the federal body that enforces employment discrimination cases, and they brought an action on her behalf under the Obama administration, saying this violates Title VII, the anti-discrimination statute that governs employment, and won in the Sixth Circuit. The Trump administration came in and switched sides, and instead of representing her, it began to support the funeral home and argued that, in fact, that was wrong and that this was not prohibited by Title VII. We also represented a man named Don Zarda, a gay man who was fired when his employer, he was a skydiving instructor, learned that he was gay. And he argued that was a form of discrimination prohibited by Title VII. He won in the Court of Appeals, but the Supreme Court took up his case. And the Trump administration sided, even though it had previously sided with Mr. Zarda and with Amy Stevens, it shifted sides in not the Trump administration, but the federal government had previously sided with both of the plaintiffs. It sided with the employers and argued that Title VII does not protect against discrimination on the basis of sexual orientation and gender identity. It was an amazing case for me because it was the first case in which transgender rights were being presented directly to the Supreme Court, a claim that transgender folks deserve equal treatment regardless of their transgender status. I was working on behalf of a transgender client, obviously, but also with two fabulous transgender attorneys who were my co-counsel. And in many ways, this was about insisting that people deserve to be treated based on who they are, not based on their sexual orientation or their gender identity. The argument was actually a fairly a sort of textual argument because Title VII prohibits sex discrimination. It doesn't on its face prohibit discrimination on the basis of sexual orientation or transgender identity. But we argued that both forms of discrimination, sexual orientation discrimination and gender identity discrimination, are forms of sex discrimination. And I'll just very briefly give you the argument. The argument is, Don Zarda, who was fired for being gay, fired for being attracted to men. If Don Zarda was Donna Zarda and was attracted to men, she would not have been fired. So the fact that Don Zarda was a man led to his being treated differently than a similarly situated woman who was attracted to men. And the same thing for Amy Stevens. You know, the fact that she wanted to come into work identifying as a woman, dressing as a woman, would not have been a problem if she had been assigned a female sex at birth. But it was a problem because she was assigned a male sex at birth. So it was the difference in her sex that caused the government to, the employers to object. So we argued that's a form of sex discrimination. It's a very textualist argument. And you know, the sort of most interesting question I got from Justice Gorsuch was, well, who is a textualist? He said, well, you know, Mr. Cole, I see the textualist argument, but what are we supposed to do if we think that this will, that you have a decent argument, but the argument will lead to massive social disruption? And, you know, my response to Justice Gorsuch was, Justice Gorsuch, I don't think it'll lead to massive social disruption. There are transgender men and transgender women in the courtroom today with us. The transgender men are following the Supreme Court's sex-based dress code for men, and the transgender women are following the Supreme Court's sex-based dress code for women. The transgender men are using the men's room, and the transgender women are using the women's room, and the world has not fallen apart. And I think the only reason I could make that argument, that is that transgender people are part of our community, they are, and it hasn't, you know, brought the world down, is because there has been a significant educational campaign, advocacy campaign over the last, you know, 10, 15 years, in which transgender people have come forward, come out, identified themselves and said, we belong, and we belong on the same terms as everybody else. And that's what made it possible for the court to rule for us on a textual argument that I think, you know, 20 years ago would have been rejected.
Well, congratulations on an amazing victory, and
also
a successful oral argument.
Well, it was really it was quite an astounding victory in the following sense, because what the court said was discrimination on the basis of sexual orientation and discrimination on the basis of gender identity are forms of sex discrimination. What that means is that not just Title VII, not just the law that we were actually litigating, but every law across the country, federal as well as state, that prohibits sex discrimination now also, by definition, prohibits discrimination on the basis of sexual orientation and transgender status. So it was in one fell swoop, the court really extended equality through a statutory decision, not a constitutional decision, but extended equal protection, in the context of employment, in the context of housing, in the context of credit access, in the context of public accommodations and the like.
No doubt that the ACLU will remain busy in all those areas. I want to shift now from major areas of litigation, and talk a little bit about the structure and role of the courts. So recently you penned an op-ed in the Washington Post criticizing the Supreme Court's use of shadow dockets, or its use of its emergency stay powers to intervene in ongoing litigation. Can you reflect a little bit about the dangers of these shadow dockets, and also some about the proper role and orientation of the Supreme Court?
Yeah. So look, I think this last term in the Supreme Court was a pretty remarkable term. I think many people were surprised by this term. This is the second term with the Trump appointees both in place. I think, and they had a lot of big cases that you would think would divide along conservative liberal lines, liberal Democratic Republican lines, and yet in the big cases, most of the big cases, the court reached what would be called liberal results. They struck down an abortion law. They extended LGBT protection across the country. They reversed President Trump's effort to rescind DACA. They ruled that President Trump had to respond to the subpoenas issued by a grand jury that's investigating potential criminal activity by he and his compadres, and from Congress, and they determined that half of Oklahoma was Native American territory. I mean, these were remarkable decisions. And, I think in many ways they speak very positively about the court as a court that can rise above partisan divide. If those issues had gone to Congress, and Congress was made up of 5 Republicans and 4 Democrats, we know how those cases would have come out. They all would have come out 5-4, the Republicans on one side and the Democrats on the other. But the court has to rise above that. The justices serve life terms. They are supposed to be applying law, not politics. And so they need to rise above the partisan divide. That gets harder and harder to do in a country that is as polarized and divided as ours. But they did it. They did it this term. They did it last term. In last term, they had 16 cases that divided along 5-4 lines in which the 4 democratically appointed justices stayed together. And again, if they were partisan, they all would have come out with 16 Republican wins and 16 Democratic losses. In fact, the liberals won 8 of them, and the conservatives won 8 of them. And every one of the conservative justices, at least once, parted company from his 4 conservative compatriots and joined with the liberals to vote for a liberal outcome. One justice did it 4 times, Justice Gorsuch. So in those cases, we've seen the court rise above partisan division. But then they have this shadow docket. The shadow docket is an emergency docket. It's a docket that in which the losing party goes to the Supreme Court, sort of leapfrogs over the ordinary process, goes to the Supreme Court on an emergency basis and says, give me a stay of some decision below. And the court decides them often in a matter of days, sometimes in a matter of hours on death penalty cases. And when it decides them, doesn't hear argument, a lot less public attention, and it doesn't give reasons. It doesn't even generally indicate how they voted. They just, come out with the result. Sometimes people write dissents so you can determine how they voted. But the majority generally doesn't even give reasons for what it is doing. And in those cases, what we're seeing is much more 5-4 Republican Democrat partisan divide. And I think that's disturbing. And I think, there's a disciplining effect from the requirement to give reasons. And I think it's critical to the rule of law. I mean, the rule of law is about being guided by principle, being guided in the next case by the requirement to be consistent with how you decided the last case, and the requirement that you give reasons, because it is those reasons that that hold you to being consistent. If you don't have to give reasons, you can act inconsistently. So I'm disturbed by how this shadow docket, which has been used much more aggressively under this administration, and the court has reached some very questionable decisions, I think, without giving any reasons for its decisions. And so, at a minimum, it seems to me they ought to give some reasons. Every other court, the lower courts get emergency petitions. They get requests for stays. They rule in days, but they write decisions. In part because they're going to be reviewed by the Supreme Court, so they have to explain themselves. But I think the Supreme Court is reviewed by us, by the people themselves, and so should have to give reasons for what it is doing. I mean, the other problem with the shadow docket is that they're intervening in cases that are not emergencies. This is supposed to be an extraordinary process, and you need an extraordinary process in some cases for true emergencies. But they're doing it in cases that don't pose any emergency. We had a case in Orange County, California, suing a jail that had failed to provide basic CDC protections for COVID for the those who were housed there. And the judge found that the failure to protect these people violated the Constitution and the Americans with Disabilities Act. He issued an injunction that basically required them to follow the CDC's guidance for what prisons should do. And instead of doing that, the sheriff appealed to the Supreme Court. And the Supreme Court intervened and overturned the order. It was an ordinary order on, the conditions of confinement in just, one prison, one jail among many across the country. They would never ordinarily intervene. There was no emergency. If anything, the emergency was on the prisoner's side, because once you get COVID, you've got it. But there was no emergency on the sheriff's side, and yet they ruled 5-4 and lifted the stay. So that's a situation where there really was no emergency, and yet they they essentially ended the litigation with a stay decision.
You described this polarization that impacts the court, or at least, very least, impacts it severely in the area of shadow dockets. But as you are a scholar of civil society, I also wanted to ask you about the impact of polarization on civil society. So in your book, you of course tell stories about individuals using the ordinary tools of civic engagement to bring about constitutional change. But what about when those tools themselves come under threat via political polarization, or also the threat of violence? So we seem to have, I think, a civil society, or even societies, that increasingly operate without a common nucleus of fact. And we've also seen currently, and in our nation's history, the threat of violence and even lethal violence descend upon movements for change. So how do we as a collective protect and preserve the role of civil society in these times?
Yeah, well, that's a great question. I mean, the worst thing I would say is that there's the fact that people, sort of operate on different sets of facts is not new. If you go back to the Federalists, and the Republicans in the beginning of our country, people were operating under very different sets of facts. They were reading different newspapers that were very much identified with one party or another. The fact that there's violence is also, not new to this country, as we know. I mean, there were major battles between, violent battles, pitched armed battles between the Federalists and the anti-Federalists in the early days. We had the Civil War. We had legal lynchings and illegal lynchings. We've had a lot of violence, unfortunately, throughout our history. So so I don't know how new it is. It's a challenge, to be sure. And I think social media gives it a different flavor. On the one hand, social media empowers people in ways that they were never empowered before to act as civil society agents. So, look at the Women's March. One of the reasons the Women's March is the largest march in US history is because of social media. There's no way in the world that before social media, you could have put together a march of 5 million people in every city across the country, and even in some foreign cities, in 4 months. There is just no way. The March on Washington, which was, I think it was one of the previous biggest marches in history, took about 1.5 years to put together, and with organizations that took much longer to sort of build up and be put in place. So in some ways, social media kind of empowers civil society, empowers citizens to take action, but as we also know, it unfortunately encourages hatred, vitriol. It makes disinformation possible because it's really largely unedited. And it makes it possible for people to sort of follow and only those with whom they agree, and not confront really the arguments on the other side, not see the humanity in the arguments on the other side, and to demonize each other in ways that I think are a threat. So, how do we get beyond that? I think, my own view is kind of an old-fashioned view. We do it through uh, appealing to our better selves. Some appeal to our worst selves. I think we need to appeal to our better selves, appeal to who we are when we, as a country, are at our best. And, I think the Constitution is in some ways an effort to hold us to our better selves. It's a recognition that, we will, as a democracy, be enticed to take shortcuts, to suppress those with whom we disagree, to deny fair trials to those we think are guilty, to beat confessions out of people that we think are not telling us, what happened. And so it puts these protections in place that are predicated on who we are when we, reflect on who we are at our best. And so, I actually think that constitutional litigation and constitutional advocacy and defending the rights of all is a critical way to sort of try to build bridges and remind us of our better selves precisely at moments when some of our worst selves are on display.
Okay, and Professor Cole, I have just one more question, which is for the students in our audience, what message would you leave for students who are about to embark on their legal careers in an era of overlapping crises and an increasingly polarized polity?
Yeah. Well, I guess I'd say a couple of things. One is, I feel incredibly privileged that I've been able throughout my career to advocate for justice. That I get up and go to work and I am arguing for principles that I believe in, for people that I believe in, for a society that I believe in. I'm not a hired gun. I'm not just defending one rich corporation against another rich corporation. I'm getting to argue about basic core notions of who we are as a community, and that is a tremendous privilege. And you give up something in doing that in terms of monetary remuneration, but I would give that up in a second, and I have never had any second thoughts about giving that up for the privilege of being able to spend every day in my work life doing what I believe. I mean, that is a remarkable privilege. A lot of people don't have that in their work life, and you spend a lot of your time working. So there's a real, I think, payoff in doing this work for yourself, that you just will, feel better about your place in the world and about what you're doing. But it's also a payoff in terms of making the society a better place. I think that the more people are engaged in sort of coming together around commitments to our better selves, the more likely we will actually get there. And in Engines of Liberty, I have two quotes that one I begin with and one I end with, and I'll just give you those here. So the first, the one I begin with, is from Judge Learned Hand, and it's from a speech he gave in 1942 in Central Park at a naturalization ceremony for like 120,000 newly immigrants who had taken the oath and become citizens, and they held a big ceremony in Central Park to celebrate this. I mean, think about the difference between that view towards immigrants and the view that we have today towards immigrants, just night and day. But in his speech, The Spirit of Liberty, he said, "Liberty lies in the hearts of men and women. When it dies there, no court, no constitution, no law can save it. While it lies there, it needs no court, no constitution or law to preserve it." Now, I think this is an overstatement. I think we actually need a constitution. We need laws. We need courts for some of the reasons I've talked about. But it recognizes a critical principle, which is that for liberty to be meaningful in this country, it has to lie in the hearts of men and women. And you, as law graduates, have the ability to to live that, to fight for liberty, to advocate for liberty, to use the skills that you've learned at University of Arizona to really make the world a better place. The second quote is a quote that comes from a book by Cornel West and Roberto Unger from probably 15, 20 years ago. And it's about hope. And they say, hope is more the consequence of action than its cause. Hope is more the consequence of action than its cause. As the perspective of the spectator favors fatalism, so the action of the agent produces hope. As the perspective of the spectator favors fatalism, so the action of the agent produces hope. And what they are saying there is, some people ask me, like, how can you be hopeful? How can you be optimistic? And what they're saying is, it's not that hopeful people act. It's not that you're born with a DNA of hope or not. It's rather that if you act, you produce hope. It is the action of the agent that produces hope. Hope is the consequence of action, not its cause. And I think that's very true. And similarly, the perspective of the spectator favors fatalism. So if you sit back and you see, the world is falling apart before you, and you think there's nothing I can do, and you just spectate, you will become fatalistic, and you will that will snowball. And it'll be harder and harder for anyone to make a difference if everyone's sitting back and being fatalistic. But it's also true that if you get up, if you stand up, if you take action, you produce hope. And that too has a snowball effect. The more people get up, the more people take action, the more you can bring about change in a direction that you want to bring about, and thereby build hope. So I think you have two choices. You can sit back and be fatalistic, or you can stand up, take action, and produce hope. And that means I think you have one choice. Thanks.
Well, thank you, Professor Cole, both for an illuminating and thought-provoking conversation, and also for the actions that you take daily to produce hope for all of us. So this concludes our public program, and we hope all of you in the audience enjoyed it. Members of the McCormick Society, our conversation with David Cole will continue using a different Zoom link. If you're a member of the Society and didn't get a chance to register for the members-only conversation, it's not too late. Bernadette Wilkinson has emailed you a registration link during our program tonight, and you can sign up now to attend at 6:45. For everyone else, thank you again so much for joining us, and our huge thanks again to Professor Cole. Have a wonderful evening, everyone.
Thank you.